It's not even an official.
Do this. Uh, Monday, March 13th, 2023, we have our City Council and Planning Commission Land Use Training. 6 o'clock meeting, work session. We have Josh Soper here with Barry Elsner and Hammond to run the training. Is there anything from planning or Alex before we begin? Or do I just turn it over to Josh?
And turn it right on over,
Right.
Josh.
Josh, go for it. Thank you.
Great. Looks like we've got some people online too, so
We do, so the online people can hear you.
Yeah,
bring it a little closer
for a
here.
good recording.
Okay.
Yep.
All right. So just a little background about myself. I've been with Beery Elsner and Hammond for 7 or 8 months now only. But before that, I've been doing local government law exclusively since 2011. I was the county counsel in Coos County in-house, and then in-house city attorney in Sherwood for about 7 years in Sherwood, 4 years in Coos County. I've been doing land use that whole time, as well as general governance type municipal law. And I'm here to talk to you this evening about land use. Here is a agenda for this evening of the topics I want to cover with you. I do have at the end an opportunity for questions, but I also welcome questions throughout the presentation. That might actually be a little easier because we're going to cover a lot of different topics to just kind of ask questions about that topic when we get to it. I'm going to start off by just talking a little bit about what land use is and kind of the big picture issues of how the city fits in with the state, different roles there. Talk about different types of land use decisions, things you need to be concerned about as a land use decision maker, bias, ex parte contacts, and conflicts of interest. Talk about land use hearings, the requirements and issues around that, criteria and findings for decisions, a little bit about appeals, and then I'm going to talk about some specific issues that come up a lot. The 120-day rule and fixed goalpost rules, you may have heard those terms before. They're in objective requirements relating to housing in particular. It's a hot topic currently, and then some constitutional issues. And any questions that you still have left at the end, we'll take those and have it linked to a few resources for additional information. So land use in Oregon is celebrating its 50th anniversary this year, and there's actually some 50th anniversary party at the Capitol coming up in a few months. I heard recently from DLCD. So if you're feeling real excited about land use after this, you can on down to that if you want. You may have heard Senate Bill 100 adopted in 1973, what kicked off land use in Oregon. And at the time, if you read the testimony around Senate Bill 100 and media coverage, really the concern was about protecting farm and forest lands, preventing urban sprawl. A lot of the conversation was about, oh, horrible things happening in California. We don't want to look like California. So we're going to adopt this bill that's going to delineate between urban areas and rural areas to protect those rural areas. That's not the only purpose of land use. The broader speaking, the purpose is to manage the different uses of lands to achieve a variety of different interests. Livability of communities, economic development, protecting resources, as I mentioned, just overall the efficient and orderly uses of land to develop workable, functional communities and ways of living. So in Oregon, the balance between state and local roles has been shifting a little bit recently towards more of a state-heavy focus. But in general, state has 19 statewide planning goals, and there are state statutes and administrative rules that implement those statutes and are guided by those goals. There's two acronyms that are very similar and often confused, DLCD and LCDC. Same letters in a different order. DLCD is the Department of Land Conservation and Development. That's the state agency that has primary responsibility for land use. LCDC is the Land Conservation and Development Commission. That is the appointed body that runs LCDC or DLCD. I confuse them already. And is appointed by the governor. And then the other acronym and state agency you'll hear a lot about is LUBA. That's the Land Use Board of Appeals. Uh, After a few years of land use in Oregon, we realized that there were a lot of appeals of land use decisions happening, and that was a burden on the courts, and also the courts dealing as they do with criminal matters and civil matters, and not kind of the specialized area of land use, maybe weren't the best equipped to handle those, at least as a primary appeal body. So the state formed the Land Use Board of Appeals, so that when you have a decision at a local level that is appealed, the first stop is the Land Use Board. We'll talk more about appeals later. In terms of cities, cities enact comprehensive plans, which is the really high level land use document. It has some high level maps, broad policy statements, the vision for the community, that sort of thing. And then and it's frequently called the comp plan for short. Ordinances then are enacted by the city council to implement the comp plan. So generally, when you're making a land use decision, you are applying the ordinances directly, not the comp plan directly, because the comp plan is implemented through those ordinances. And then the thing that we'll talk a lot more about this evening, major role for cities is to review development applications for compliance with those ordinances and indirectly the comp plan. There are two types of land use decisions that city councils and planning commissions make. Those are legislative and quasi-judicial. To understand the difference, one that might be helpful to, and we'll talk about this a lot more, but to take a step back and think about, learned in maybe high school about the three branches of government, the executive, the legislative, and the judicial. But you may have noticed being in city government, that three branches concept kind of collapses at the city level. You have a council manager form of government as you do here. To some extent, the executive is largely on the city manager, but the city council still exercises some executive roles, being hiring the city manager or enacting some city administrative type policies. But as a city councilor and as a planning commissioner, you will at different times wear a legislative hat or a quasi-judicial hat. And when you're wearing the quasi-judicial hat, acting in that role, you are acting essentially as a judge. And when you are wearing the legislative hat, you're acting like a state legislator or a senator or member of the House of Representatives. And so you visualizing those different bodies and their different roles can kind of help understand why there are so many differences between you're acting in a legislative capacity or quasi-judicial capacity and use. The line between what is a legislative decision and a quasi-judicial decision can get a little hairy at times, but broadly speaking, legislative decisions are the big policy type decisions that broadly affect a large segment of the population, large number of different properties. They implement standards that will apply to a number of different decisions in the future, not the specific decision about, say, building this particular use in this particular location. Examples would include amending the comprehensive plan, zone changes that apply to large different areas, changing the text of your development code, sort of thing. Because the city council is acting in a policy type role in legislative decisions, you're not even in most cases required to make a decision. You decide we don't want to deal with this subject. We're just not going to adopt anything in a sort of decision. And bias and ex parte requirements don't apply. And I guess one way to think about the ex parte, why that doesn't apply in a legislative context, think about lobbying of legislators, right? It happens all the time. Whereas you think about the judge, would be unfair for one party or the other to be able to talk to the judge privately and share some information or lobby them to make a particular decision on a case. Quasi-judicial decisions, generally it's only a single property or a small group of properties. Decision is based on pre-existing criteria. You apply those criteria to that decision. You're not making a policy decision. Policy decision was previously made in enacting those criteria. You're now applying those criteria to the decision. And city is required to make a decision. Somebody applies to subdivide their property. City can't say, we just don't want to with this. You have to either approve it or deny it. And most of your decisions will be generally quasi-judicial. You get a lot more applications. Typically, most cities, then you have opportunities to change the development code or the county. And as I mentioned before, because you're basically acting as a judge, there are a lot of other requirements that apply. This is where we talk about bias and ex parte contacts. Pause for a moment just on that critical distinction between legislative and quasi-judicial and see if there are any questions. Of
The-
quasi-judicial?
Oh,
Yeah, I mean,
in our town?
Yeah.
when somebody has submitted an application and you're making a decision, almost all the time that's going to be a quasi-judicial decision. So in subdivisions, site plan review is another example, and legislative, it's comp plan amendments, code amendments.
One thing I know too, which is unique in Scappoose, is that also we have limited land use decisions, which do go to the planning commission, whereas in a lot of jurisdictions, that would be a staff level review. Subdivision, partition, our site development review, those are all limited land use here. And so our quasi judicial is going to be a zone change, say just on one parcel, or a variance, or something like that, where it's not just limited land use will be more strict. Just if it checks the box, we don't say a word about it. We have to approve it. There's not this, judicial process per se. It's just more permit level almost. But again, that's something that we've talked about changing as part of the 50-year plan code changes, because it really kind of does slow down the process then to have all of the ones that we don't really get to have a say in, where we're just strictly applying criteria. Maybe it makes more sense to just do that at a staff level, and keep the quasi judicial and legislative decisions more for the planning commission and council, rather than taking even the limited land use decisions to planning commission. But that's not, that's a decision that will be made by council ultimately, as we're finishing up those code amendments.
Thank you. That's a great point. And
Yeah.
a lot of communities find different ways to strike that balance. There's a lot of factors that go into it. When we're talking later about clear and objective standards for housing, it's another question that comes up sometimes is if the standards are truly clear and objective, like a checkbox process almost,
Right.
why does a planning commission or city council to be involved with that? Other communities, the planning commission, city council just feels like they want to be involved and aware of those things. But there's an understanding that there's not a degree of discretion in your decision making. Those criteria.
It looks like Scott online had a comment.
I just wanted to say, when you're saying quasi-judicial is like a judge, I feel like it's a lot clearer to say you're like a referee. The rules are already laid out in the development code, and the job as planning commissioners or city council is make sure people are following the rules correctly.
Yeah, thank you. That's another good way to think about it. Is you're applying the rules. I think the judge analogy is helpful when you think about kind of the expectations that we have for fair hearing and that sort of thing. But referee is another good analogy.
I have a question. So in cases that it won't go to council or commission, planning commission, um, will the public still have say in that process?
Yeah, so we still have noticing requirements. The neighbors within so many hundreds of feet, depending on the type of application, are still noticed. There's still a public comment period that we would take those comments and consider them and include them in, recommended conditions of approval. If they're related to code criteria, we can't just tack them on because somebody asked for a fence or something if it's not in the code and it requires it. But yes, they absolutely still are noticed of the pending decision.
And are given the option to comment? and
Yes.
give their opinion.
Yep.
Okay.
Yep.
So again, the critical thing, I think, particular as a city councilor, most of the decisions you make are legislative outside of the land use context or administrative executive. And there's not very many contexts outside of land use where you're making quasi-judicial decisions. So it can feel a little foreign, especially if you don't get a lot of those that come to the city council. It's almost constraining in a way. You feel like you are elected to have more of a discretionary role than what is allowed in a quasi-judicial context, where these are the rules, these are the criteria, this is the application. You have to make a decision, and if it meets the criteria, you have to approve it. Just it can feel a little strange. So that's a lot of, in particular, newly elected city councilors, I think, struggle with.
We approve it even if we don't like it in that circumstance.
Exactly. Yes.
We don't say we don't like it.
And
Yeah.
and the city wouldn't be putting it in front of us if they didn't feel that every criteria was met, correct?
Well, yeah, so what we do, technically, even if it didn't meet, we could, as staff, make a recommendation for denial if we're seeing that it's not meeting the criteria. What we do, however, is add conditions of approval to make sure that it is meeting the criteria before we bring it to you. We haven't had an application yet where we weren't able to do that, so that we could recommend approval based on what's being presented and the conditions of approval that we have included, which we always share with the applicant before we bring it in.
And the practical reality there too is that a developer is usually is going to work with staff to get to the point where there can be a recommendation of approval. They don't want to bring something to a planning
Yeah.
commission or city council where the staff is recommending denial. It happens, but it's rare because then they know it's pretty unlikely that they're going to get an approval from the planning commission or city council, and they're going to have to appeal it to LUBA. They're generally going to be flexible to get to that recommendation.
Pretty high bar.
Can't hear you.
NFU and Scappoose, South Fork, Buxton, Steinfeld Acres, those are all planned unit developments. So they're actually asking for a code modification for those projects. We make sure that, we're really looking at those pretty closely before we stamp them.
So if the criteria you're just saying cannot be met and then you've done conditions of, use, that is your discretion of, okay, we feel that if they do this, then it will suffice to the criteria requirement?
Yeah, but typically, it's not to say, like, we're going to have them demonstrate that it's feasible, but we're not just going to say, well, we're not quite sure if you can meet this, so we'll just add a condition for that. I mean, we're making sure that we feel that they can meet that condition. Otherwise, it wouldn't make a whole lot of sense.
So, yeah, and in the past, there's been some leeway on street and utility standards, setbacks. What else? Lot sizes, things like that.
So if the planning commission looks at it, they see that it hasn't met criteria, but the condition that of approval is such that.
Yeah.
But the planning commission can't vote on that or decide on your condition of approval.
On those, they're making a recommendation to council.
on that in particular. Some are wholly within their ability to approve, and in that case, yeah, they would be the one making the decision. It just depends on the type of decision it is, and if it's council approval level or planning commission.
Would you want to mention which applications are? council?
Let's keep going through,
Always.
and then we can always, if there's questions.
And just real
Quick
quick,
question.
on
The
the
only reason it came to us was two I've dealt with is because there's a zoning change.
That's correct. Well, I think the first one for you was an annexation. Because the Maple Street cottages was an annexation, right? So it's changing the zoning map. It's bringing land into our territory and changing the zoning map. So it came to council. And then the second was the plan development, which also acts as a zone change on that one particular parcel. And again, that's why it came to council.
And just to close that loop a little bit on the conditions of approval. So if something clearly doesn't meet the criteria at all, like if somebody's proposing to put a house in an industrial zone where it's not allowed, you can't condition that into compliance, right? But if it's, for example, needing to obtain access approval from ODOT or something, they don't have it yet, they're required to have it, you can condition the approval on obtaining that in the future.
I think with me, examples really help.
Mhm.
Scott, you have another question?
Less a question, but just to kind of add in, uh, if it just escaped me, I apologize.
We'll be here.
It'll come back to you.
All right, so if you like examples, you're in luck because I'm going to give a lot of examples about bias. So next few slides are about we talked about acting like a judge or a referee. This requirement that you have an impartial decision maker. So bias is a big part of that. Bias occurs in land use decision when the decision is not based on applying the facts and the law, applying the criteria to the application, based on some other reason that you would have approved or disapproved, voted to approve or disapprove of an application. And it's difficult to describe the parameters of that in the abstract, and there's been a lot of case law about when bias exists and doesn't exist. So that's why I'm going to go through a few examples to show kind of where some of those lines are. But it can be difficult to predict how LUBA is going to rule on a bias question, frankly. So here's an example from the city of Depot Bay. This is a situation where before the decision was made, city councilor sent a letter to the mayor and other city councilors basically saying this application should not be approved. And because of this is really a timing question. If a city councilor said those exact same things at the hearing where you were voting and making your decision, that would have been perfectly fine. Because the city councilor had already formed an opinion before hearing the evidence, before conducting the public hearing, that was evidence that the city councilor had prejudged the application. It was not making that decision based on facts and the law in that application. This case out of Cottage Grove, a city councilor sent a letter to the editor encouraging opponents of the project to leave town, and also requested police logs regarding the project opponents, and critically added those to the record of the land use proceeding. And in that case, it was said pretty clearly there was bias. Because the city councilor was acting outside of their role as a judge, they were acting as an advocate. They were adding information to the record, which is not the city councilor's role. That's the role of the project opponents and proponents. This case out of the city of Jacksonville, city councilor was a member of a church that applied for a conditional use permit and made a decision on that conditional use permit to approve that permit. LUBA Luba found in this case that there was not bias. And this is really, I think, a critical case because it shows that even when there are some factors that could suggest that somebody could be biased, if the decision maker acknowledges those on the record and states an intention that I'm, despite these other factors, I'm going to listen to all the evidence, I'm going to apply the criteria, I'm going to make a decision based on the evidence and the criteria. I'm not going to be biased in my decision making. And then the record shows that they actually do that. They don't make comments that are inconsistent with that. They make comments that are about the criteria, about the evidence in front of them. And Luba is very unlikely to find bias in that situation. This is one of my favorites because I learned a new term out of it. I think we've all heard about NIMBYs, not in my backyard. This one was a city councilor using the term banana that I hadn't heard of before 2016, which means build absolutely nothing anywhere near anything. NIMBYs just don't want it in their backyard. Bananas don't want anything anywhere. But city councilor referring to opponents as bananas is not enough to be biased. That's it on bias. Any questions on bias? Talk also about ex parte contacts. Again, as I mentioned before, this goes back to the concept of being a judge, and you need to have both parties there when you're talking about a case. Similar concept here. Any communication or information that's received outside of the record, which can include site visits, and is an ex parte contact. And the reason for that is that if you're making your decision based on some information, the other parties to the decision making process in the hearing need to be able to know about that information and have an opportunity to rebut that information. The important thing is that an ex parte contact does not invalidate a decision. If you have an ex parte contact, that's fine. You just need to disclose that ex parte contact at the hearing quickly to give people the opportunity to rebut it. The place where a lot of people trip up on this is you don't just disclose the fact that a contact occurred. You have to disclose the substance of that contact. That's frankly why I encourage people to avoid having ex parte contacts as much as possible, because it can be very difficult. You have a 5-minute conversation in a parking lot after a city council meeting. Then at your next council meeting, you have to disclose the substance of that communication. It can be difficult to remember everything that you talked about and disclose everything. Also, because an ex parte contact does not mean that you have to recuse yourself. That's why my advice is always to err on the side of over disclosure. If you're not sure if something's an ex parte contact, talk about it anyway. No harm is going to come from talking about it. Not talking about it can cause a remand or reversal. There are some important exceptions. Communications with staff are not ex parte contacts, and communications before an application is submitted or after the final decision are not ex parte contacts. I have a little note about more on this later to give you a little preview. Sometimes you don't know when the decision is really final. Things can come back to you. So I caution against having an ex parte contact even after you think you've made a decision.
And it looks like Scott has his hand up.
When you're talking about site visits, is it actually being on the site? Because I would think it would be all right if you view a site from a public right of way, because that's available to anybody.
Right. So it's about gaining information that is outside the record. Sometimes I'll see city councils or planning commissions where they ask for people to disclose ex parte contacts, and every single person they go across and say, "I've driven past it before." Oh, that's not necessary, right? If it is a location in the community, that in a small community, virtually everyone has seen the property probably at some point. What we're more concerned about is, if you're walking the property and you think that, oh, based on seeing it myself, I think the slopes are greater than 25%. There's information in the record about what the slopes are. Well, then you have potentially basing your information on different information than what's in the record. Made your own judgment based on site visit. Or what often happens is during the site visit, you have a conversation with somebody. Answer your question, Scott?
I mean, sort of. Um, like, and I understand all the points you're raising, but uh, for me, it's, like you say, you've seen it before, and if it's in the public right of way, it's available to literally everybody. And there is a value to seeing things, but I don't think that, it's pretty redundant to say I looked at things from the public right of way because there's nothing special about that, and there's no communication.
Right. It's about the having information outside the record. So you're unlikely to gather information from the public right of way that's not going to be in the record. I think that's a generally fair assumption. I think if you feel like you've seen something from the right of way that is going to potentially be valuable information to your decision that is not the record, I would err on the side of disclosing it. Generally speaking, yes, seeing it from the right of way is not going to be something to be concerned.
Thank you.
Social media, yeah, that's great. Same rules apply on social media. It's just makes the world a lot more complicated, right? Because you can be just scrolling through Facebook, for example, and see somebody else posted something, and you didn't seek out the information. They didn't direct it specifically towards you, but you see somebody's comment that's relevant to a land use decision. That is an ex parte contact. You need to disclose that. That would include, it could include, reading an article in a newspaper, any information that's not in the record.
And does this happen too with like zoning change when you were thinking about changes in zoning? Do you still go through this kind of a process?
Do you mean, like as part of the 50-year plan consideration?
Yes, if you're gonna start making some changes, maybe like we did before, and you're thinking of changing some zoning, it goes through this whole same process and the same ex parte or same, going on the site, like, hey, we want to change this from industrial to commercial, or you're starting to make changes. You're presenting everything to the planning commission or the council, and that's what we have to judge it on.
That's correct.
And if you-
Unless it's legislative, where we're making whole scale changes that are going to affect, large portions of the city, changing development code, things like that, which will be kind of the outcomes of the 50-year plan. Then that would be legislative, in which case, bias and ex parte don't apply.
So you could drive around, you could look at the sites, you could go make your own judgments, look.
Right. I mean, zone changes are a difficult one because that's often where the line between legislative and
Yeah,
constitutional breaks
yeah.
down. If you're zone changing one specific property, that's almost always going to be quasi judicial. If you're doing, as Lori said, wholesale, broad brushstroke type zone changes, that's almost always going to be legislative. Sometimes it's somewhere in between and it's more difficult. But if it is legislative, plan update or changing the development code or these big zone changes, not only can you do site visits, you can have one-on-one conversations with members of the community and you don't have to disclose those.
And you can bring your personal opinion to the table. Like, I just think that's a bad idea. That's fine, as long as it's legislative and not quasi judicial.
Yes, you're welcome to be biased for legislative.
Yeah.
That's part of your role as an elected official.
And if we're in an instance where there's just one piece of land being
Mhm.
rezoned, is that usually the result of an application?
Mhm.
Okay.
Correct. Yeah. Yep.
Conflicts of interest is something you might be familiar with because it also applies, in fact, maybe even more often applies outside of the land use context. It comes up more often. This is under Oregon government ethics law, where there's the difference between actual and potential conflicts of interest. And actual is where decision will result in a financial benefit or detriment potential is where it could result in a financial benefit or detriment. That's to you, relatives, members of your household, businesses you're associated with. You have to disclose in both instances. And when it's an actual conflict of interest, you have to recuse yourself and not participate in the decision making process. My recommendation in those cases is always to leave the room and disengage from the process entirely. It is possible, maybe unlikely, but it is possible that you could be found to have a conflict of interest issue just based on gestures or facial expressions that you're making influencing the decision from the back of the room. So my recommendation is to leave the room. It can obviously, as if you think through where a conflict of interest would come into play, that can overlap a lot with bias. And the important thing to think about here too is because this is ethics law, not just land use law, in addition to creating issues for an appeal or a challenge to your decision, there can be personal liability for the official who made a decision where there was a conflict of interest, which can include fines and when there's financial benefit up to double the financial gain.
It looks like Bill Blank has his hand up.
Yeah, can you hear me okay?
Yep.
Okay, and what are the situations, and this has happened before, where something might be something job related or whatever, and you say, yes, I've been exposed to this, I know this. I'm not going to make a decision, I'm not going to vote on it, but I can sit in and listen to what is going to be about, and you don't leave the room. You know what I'm saying? There are situations where people just sit up there, but they don't take an action on it itself. Are you concerned that also their facial expressions and things like that might have some effect on the people out there? It would be better to leave the room.
That's exactly right. So there are different levels of recusing yourself that different people take, and tends to be almost tradition in a community what people do. Some people will still sit up at the dais and just not participate. Other people will step down from the dais and sit in the audience. Other people will leave the room. My advice, admittedly, is the most cautious advice, but if you leave the room, I can't imagine a situation where you're going to end up with an ethics complaint. It is feasible if you're in the room still that you could be perceived to somehow be influencing that decision through your official role. So I would encourage you. You're not required to leave the room, but I would encourage you to.
I see, because there's still a possibility that, like you say, on a field basis, it may work against you.
Right, on an appeal of the decision, and also if you received an ethics complaint against you personally.
Right. Okay, thank you.
Do we see this in a small community like ours? Do we see this then from time to time? I mean, are you expecting potential conflicts and so people will recuse themselves?
Yeah, it's not. I mean, it's not entirely uncommon, right? Because it's a small town. So, maybe you've done business with the applicant, or, it's your neighbor, or, it's not entirely uncommon.
Typically, is it financial then, the benefit or detriment? Not like if it's a friend or a neighbor and they're trying to get a business, but there is absolutely nothing that benefits me other than using the business.
That's a funny thing. It surprises a lot of people about ethics law in Oregon. It is only concerned with financial conflicts of interest. And to your point, Mayor, yes, the smaller the community, the more often it comes up, frankly.
Yeah.
You're more likely to be proximate to the location,
Mhm.
you're likely to have a business relationship with the applicant,
Right.
or to be yourself engaged in a business that could benefit from the application or be harmed by the application, or to have family members meet any of those criteria.
Well, for instance, Bill Blank, who's been a planning commissioner for over 20 years, often knows the applicant. And will have to declare he sat on a board with them, or, he's very good about just declaring, that he knows the person, and he sees no issue with being able to fairly, look at the application and make a decision. So it's always best to just get that out there. If you think you have a conflict of interest, we just ask that you contact staff and we'll help you figure that out.
Yes, and thank you. That's my last bullet point there is call OGEC, which is the Oregon Government Ethics Commission. They have a free hotline. They will talk through these issues as well and give you advice.
And if you call them, you're covered. Basically, if you call and explain to them and you go with their recommendations,
There are some limited safe harbor provisions, yes. Okay, let's talk a little bit about hearing requirements. So I'm going to focus on quasi-judicial hearings. There are some other requirements for legislative hearings, but quasi-judicial is where people most often get hung up. So there will be public notice requirements and DLCD notice requirements sometimes for legislative decisions. And those can vary based on the type of application and city code requirements. Typically, staff will provide a script to open the hearing, which will address all the other kind of things that are required to be said at the beginning of a hearing about raise it or waive it, which is if you don't raise an issue now, you can't raise it for the first time on appeal. Identifying the applicable criteria for the decision. At the initial evidentiary hearing, anyone can request time to present additional argument or evidence, and that has to be granted, either by holding the record open or by granting a continuance. And applicants get 7 days after the record closes to submit final written argument. As I noted there, the applicant can waive that 7-day period. And I will say they virtually always do because they want a decision sooner. I don't see them exercising that right very often, but it is technically there.
Question.
Yes.
What's the timeline if you want additional time to make your argument or to make your argument? Can you do it the day of the meeting? Or do you have to do it 24 hours in advance or how does that work?
For the initial evidentiary
Yeah.
hearing bullet. Yeah, so we frequently call that the 777 rule because it's 7-day increments where you have to provide at least 7 days for somebody to present additional argument or evidence, and then 7 days for somebody to rebut that. Then the final 7 days is that final written argument. So if you do an open record period, you're typically looking at least 3 weeks before you can come back and make your decision.
So if you want to say something, initial evidence you're hearing, you need to do that 7 days in advance.
No,
7 days after.
during the hearing, at the hearing, you can request, anyone can request
Request to do
At
that
the hearing. at the
Is there a
hearing.
time limit to that?
It's
So at any
during
point,
the hearing.
any point during that first hearing, somebody can say, I want more time to respond and make more argument or submit some additional evidence. Anytime before you close that hearing. Then you have to give them at least 7 days to do that.
And can something like that, a process extend the application because somebody else comes in 7 days and says, I have more time, ends in 7 days? Can that, I guess the loophole be that you can keep extending that application? Because
Are
I
you
know
talking about the 120-day.
right.
Right.
And then there's a timeline that you said, that I think that's what happened with us. We had a timeline that
So
we were
the
cut
rule
out.
is that if the extension of time is requested by the applicant, then it will extend that time. But otherwise it will not. And so it's important when you're building out the timeline for approving an application, you take into consideration the fact that you could have this additional 3 weeks essentially after that first evidentiary hearing if somebody requests.
So just to get the 3 weeks right, I mean, we first have to announce the meeting and the public hearing. Does that start the first 7 days? Or is it
The first 7 days starts at that hearing.
at the first meeting? So then during the meeting, they say, we want 7 more days. So you grant them 7 more days. And then 7 days from then, the applicants get 7 days rebut, or
Or anybody can rebut. A
Anybody
member
can
of the
rebut.
public could rebut.
then what's the last 7 days after?
Final written argument from the applicant.
That rule applies to both the applicant and the opposition.
In terms of being able to request an additional 7 days, that's correct, yes.
Question.
Oh, we have a question, yes.
Bill,
I will say that the staff has this as usually a statement at the end of the hearing to allow those people an opportunity to do that. I believe that's pretty normal process, isn't it?
Yes. We don't ask anyone if they want to extend the hearing. No. There
Okay.
is a process by which the normal hearing procedure, there is rebuttal by the applicant during the meeting, but this was talking about if someone had requested to hold the meeting, hold the record open for more information. Slightly different.
But you don't tell them that they have the opportunity to hold the record open for 7 days in your statement at the end of a hearing.
No.
Okay.
And I will say that it doesn't often come up, but when it does come up, sometimes you're in a tight spot because of the 120 days if you didn't put that into your math or when to schedule your hearing.
Remind me, Lori, the last case that we had, it's because we were at that end of 120 days. Is that right?
Yeah, we
There
were
was no more time.
correct. And the applicant did not say that they would extend past.
had they extended past the original
They
120?
did. Yes, they did.
Remind me now, like on the Oxbow, was that at the planning commission as well?
That did go to planning commission because it involved sensitive lands permit approvals, which are quasi judicial.
But none of this, could this have come up, but nobody,
Oh, yeah. So
Yeah,
anyone
nobody-
could have
nobody-
asked. Nobody needed the additional information. We didn't have anyone in the audience. Nobody, the planning commission felt that they had all the evidence they needed in front of them to make a decision that night.
Okay, this next slide is a little bit about just broader hearings issues, and this really applies to all public meetings. But because land use hearings can get a little more heated, maybe it comes up a little more often. Presiding officer, which is going to be the mayor or I guess council president in absence of the mayor or a planning commission chair, has inherent authority to maintain order and decorum in public meetings. That is something that courts have consistently held. That includes setting reasonable rules for conduct of meetings and the order and length of public testimony. A lot of times those things are established by ordinance or council rules or some similar document. The presiding officer has that inherent authority in the absence of those documents. For disturbances, that's anything that's disrupting the public meeting or the hearing. The recommended procedure is to provide a warning. And then if that behavior continues, ask the person to leave the meeting because they're disrupting the meeting. And if they don't leave, then they can be treated as a trespasser. That typically involves a call to law enforcement or if you have a law enforcement officer present, they can that situation. My advice from experience is if you have to have somebody moved from a meeting, call a recess from that meeting. Otherwise, they will take advantage of the podium that being removed from the meeting. Questions about any of that?
So behavior would be disruptive, loud, rude, right?
Clapping.
Right. It's not just giving their opinion and
Correct.
right,
Right.
and information. Okay.
It is something that disrupts the conduct of public business, not exercising your rights to public comment. So if it's your 3 minutes or whatever your length of time is under your rules at the microphone, then reason you can say almost anything. I mean, there are things that you could say that would be disruptive, actually. But generally speaking, you don't want to, can avoid it, make these kind of determinations based on somebody's saying. Then if their time is up and they go to the back of the room and they're shouting from the back of the room or they're clapping or booing, that's the sort of thing that we're talking about. That's disrupting the conduct.
You.
I've mentioned about in the quasi-judicial context about how you have to apply criteria to the application and make a decision based on that. So kind of just reiterates that the criteria, the approval or denial of an application must be based on those standards and criteria, and those standards and criteria must have been adopted by ordinance. But typically, that's your development code. Potentially, it's also something like a transportation system plan, sort of thing. And then when the decision is made, you have what is called findings, which is a statement explaining what those criteria are, facts that were relied on to make the decision, and the justification for the decision based on the criteria. The facts must be come from substantial evidence in the record. And if there are conflicts in the evidence, you want to, in those findings, resolve that conflict. So sometimes if you have very organized opposition, for example, you might have a applicant who has one traffic engineer that says one thing, then you have a opponent who has a traffic engineer that says something different. You're going to want to say something in those findings about why you are believing one traffic engineer over why one is more credible, or their study was more robust, or whatever, how you're resolving that conflict in the evidence.
So I mean, looking at criteria, at times you could look at it, it could be subjective or not black and white, and you're listening to two experts and they could come up with different findings based on the evidence. And then you just have to justify or explain why you're going with the decision that you are.
That's exactly right. And so there's a bullet about the decision must be based on substantial evidence in the record. That means A, the evidence has to be in the record, and B, what substantial evidence essentially means is something a reasonably prudent person would rely on when making decisions in their own life. If you follow these steps in your decision and you're weighing competing evidence and making a determination, LUBA is not going to reverse you or remand your decision because they choose to believe the other person, or they weighed the evidence a little bit differently. They're going to defer to your weighing of the evidence as long as that evidence is substantial evidence and it's in the record. Which brings us to appeals. So for the appeal process, there's typically local appeals and then there's further appeals to local appeals. Applications are generally in most communities divided into categories in the code, often type 1, type 2, etc., which determines who the initial decision maker is and then the appeal process. So sometimes you'll have planning commission makes the original decision and its final decision, unless it's appealed. The appeal would go to city council, for example. When there is a local appeal, that appeal can be either de novo, which means a completely new hearing process, or on the record, which means there's no new evidence. You are basing your decision on the evidence that was submitted to the record at the prior decision-making level. So for example, the planning commission made the original decision and it was appealed to city council and the city council was doing an on the record appeal. That would mean there's no new traffic engineers coming in with their new reports. There's no additional evidence. Typically, you have to, in most cases, allow for additional argument, is why you should believe this evidence, why this evidence meets this criteria, that sort of thing. There's no new evidence. You would only be looking at the evidence that was submitted at.
But you would be listening to the arguments if the applicant came in and gave a different story or added on to their original, be listening to that as well.
Right. They may, I mean, it could happen that they didn't have an attorney at the planning commission level when it got appealed to city council. They decided it was time to bring on an attorney and that attorney is going to have some different argument for why the criteria is met based on that evidence, but not submitting new evidence if it's a hearing.
If it's a decision like we were talking where only the staff, the planning commission, or not planning commission, but you see it and you reject one and they appeal, do they appeal first to the planning commission?
Yeah, it would always go from staff level decision. If there's an appeal, it would go to planning commission. If there's an appeal of planning commission, it would go to city council.
Watch the person make it.
No, our
Your
code,
code.
it's in our code. The code spells that out.
And I haven't looked at your code. Some codes are lacking in clarity on that subject. So if you have any question, that might be a good opportunity to look and check. And for what it's worth, I think generally speaking, de novo is a better approach because it can it can be a little awkward to not be able to take in additional evidence at the city council level. Also, it allows you an opportunity to fix mistakes that may have been made at the planning commission level. So if planning commission decided not to allow certain evidence into the record, for example, or somebody didn't have the staff report far enough in advance to be able to respond to it, that sort of thing. Novo allows you to basically cure that. The downside is that the de novo process, it means a full hearing. It's more time consuming. It's a more involved process for the city council.
I would definitely, Lori, then if we feel that looking at the ability to you guys make decisions at staff level, make sure that in our code, if there is an appeal or what is the process, we'd like it to be clear as possible.
After that, after those local appeals are exhausted and it is the city's final decision. If a applicant or opponent wants to appeal further, that's when they go to the Land Use Board of Appeals. And then from there, it could go to the Oregon Court of Appeals and onward Supreme Court. That's the appeal process from there. At that point, it's out of the city's hands. However, and I alluded to this earlier, remands happen quite often when something goes to Land Use Board of Appeals. So be mindful that if there is an appeal, it may result in a remand and you may be making a new decision based on that same application in the future. Remand essentially means LUBA says, you messed something up, try again. And so then you're back to making another decision on that application. So keep that in mind when it comes to things like bias and ex parte contacts after your decision, before that decision is final. If the time period to appeal to LUBA runs out and nobody's appealed, then you can be comfortable that that decision is final. If it is appealed to LUBA, then there's a possibility of and the same, actually, it's uncommon, but the same can happen. Planning commission decision appealed to city council. I have seen city councils remand back to the planning commission, say, we want you to look at this again. We have enough time in the 120 days clock, 120-day clock. That's pretty rare, but if there is, send it back to the planning commission and have them take another look at it.
And are those pretty specific? I mean, if you go to LUBA, you're appealing specific items. And then they look at it and they send it back on just that item, potentially, not the whole case.
That's correct. So when you appeal to LUBA, you have to specify what your grounds are for your appeal. And then the argument's going to be limited to those. And as we talked about previously with the raise it or waive it, it's something they have to have brought up previously at the hearing.
And remind me, what's the time frame for a LUBA appeal? Like, is it 90 days that kind of need to be conscious of potential ex parte communication from a decision, or
21 days.
21 days? Okay.
Can you also remind me of when the 120 days start?
120 days starts when the application is deemed complete. And I think that may actually be my next slide.
Okay.
There we go. Perfect timing. Thank you for that segue. So the 120-day rule means that the final decision, including all local appeals, has to be made within 120 days after the application is deemed complete. So I guess to take a step back there, and somebody submits an application, staff reviews it for completeness, and will either deem it complete if it is complete, or they will notify the applicant that something's missing. Give the applicant an opportunity to submit that additional information, or the applicant has the opportunity to say, that's all you're going to get. Deem it complete anyway, even without getting the additional information that you think is necessary. At that point, when it is deemed complete for either of those three reasons, that's when the 120-day clock starts. If you don't make a decision within that 120 days, there are a couple of consequences. The first is that the city is required to refund 50% of the fees or deposits or the unexpended portion, whichever is greater. So some cities have you put down a deposit and then bill against that deposit. And if you get to the 120 days and you've only used up 25% of the deposit, that 75% is going to get refunded, just the 50%. If you've spent it all, the 50% is going to still get refunded. The other consequence is that the applicant can file for what's called a writ of mandamus in circuit court, where the circuit court basically takes over jurisdiction of the decision-making process, and the court will approve the application unless the city can show that it would violate code. So, in particular, is concerning in areas where there's some level of discretion in the decision-making process. The court is not going to disprove or going to reject an application because you think there's some good reason why they shouldn't. If it does not strictly meet the criteria, they will reject it. Otherwise, it will be approved. Practical reality is that it's not a zero cost endeavor for an applicant to take something to a circuit court. It's time consuming, and it's not a guaranteed outcome. So sometimes if you're close to the 120 days and decision is going to be delayed by just a few days or a few weeks, but they think it's probably going to result in an approval, they're not going to pursue that writ of mandamus. But there's absolutely no reason for them to not at least get the refund that they're entitled to.
And how long does it take to get to that point? Varies on every application. I mean, some are in works for a year, 2 years, 3 years before we get to the complete application.
No, it doesn't typically take years. But it usually does take at least 2 passes, sometimes 3, before, and we don't know how long it'll take before they submit back the information we've requested. But again, that clock starts once we've deemed the application complete.
And you guys give us updates from time to time of every application you're working on, or do you let us know when they're complete and the clock has started?
Well, so in our council update, you'll see where I'll note, inquiry meetings, pre-apps, things like that. So typically once it has shifted from being just in a review process to being deemed complete, you'll notice that I'll state like what date it's going to planning commission. So at the time I deem it complete is when it gets scheduled for planning commission.
And then that's kind of when you'll tell us, yeah, planning commission or not at all, because it's your decision or staff decision as well.
Yeah. Yep. I had a question for Josh, just curious. So it says it could be extended in writing up to 245 days. Is that from the date it's deemed complete or after the 120 days is up, they have an additional 245?
It's an additional 245. So if you do that math, you'll see that it adds up to 365. It's 1 year.
Okay. Okay.
Next year will be a day off, but
Okay.
It's generally 1 year, right?
Okay, thanks.
Right. And then I think the other to kind of one of the other questions was about how long it can take to deem something complete. Under the statutes, they have a maximum of 180 days
Mhm.
for that the application is void. So for this extension of the 120 days, as you see, I bolded there in writing. That's something that cities get tripped up on sometimes. Is somebody agrees verbally at the hearing to extend it, and then changes their mind afterwards, or nobody follows up on it and gets it in writing, and then they make an argument that they never actually extended it. So my recommendation is to have some blank forms. We have some templates that I use in my office for folks who want them, where you basically just write in the name of the application and you write in the number of days they're extending it and sign it, have them sign it right there on the spot. So you can't have a change of heart later. Yes.
So just to kind of explain a little bit more, the 245 days, what are the conditions of having them extended? Do they have to have um, request more information? Do they have evidence that need more? I mean, what is the requirement of the 245 days extension?
The only requirement is that the applicant agrees to it.
Sorry, say that again?
The only requirement is that the applicant agrees to it.
In writing.
In
Applicant,
writing, right.
in writing. Okay.
So,
That's the only conditions, is it has to be the applicant.
correct. And so sometimes it will come up that the applicant requests it because they want an opportunity to provide additional information. They see the writing on the wall that the application might not get approved and they want to provide more information or an opportunity to respond to some things that came up during the public hearing. Oftentimes a decision-making body will say to the applicant in the hearing, you know, we don't feel like we have enough information to approve this based on what we've heard this evening. We're up against the 120-day clock. Will you agree to extend it so we can have an opportunity for you to convince us essentially to be able to approve this? Applicants will usually grant it in those circumstances. They typically, the reasons they won't grant it is if they think that they're not going to get an approval anyway, or if they feel like they are up against some other time pressure, you know, like the in-river, in-water operations or just their project needs to be constructed starting in June and their whole construction schedule is going to shift if they don't get their approval. Generally speaking, applicants want to get to yes, and they don't want to have to deal with a LUBA appeal to get there. I wouldn't be afraid to ask for it.
If during the application, one might be a transportation study, the application is not complete until you've received that. And
That's correct. So with each application type that we process, there's a submittal checklist in the back of the application. And even if they've submitted all of that, if we're thinking through the application and we're not sure if we have the information we need to know that they're meeting the criteria, we can ask for additional information as well. Typically, we don't have to do that. We're capturing that in those in that checklist for what they need to submit, and then the code also will spell out what's required for each type of application. But yes, we wouldn't deem it complete if the traffic study was missing.
the time frame isn't really waiting for other reports or studies to be done when they ask for extended.
That's why we do, yeah, so we don't deem it complete until we know we have everything we need, yeah.
Now, I have seen it, it's rare. Again, as I mentioned, applicants usually want to work with staff to get to the recommendation of approval and so forth. As I mentioned, the statute does have the provision that says that an applicant can say, I'm not going to give you that information. You need to just deem it complete anyway.
Mm.
And sometimes if they're on a really tight clock, sometimes they'll do that and then submit the information later. Or they will, if they don't believe that that information is actually necessary to meet the criteria, they'll just never submit it.
So going back to that 180-day application period, so say they submit, they understand the information that they need to produce, that 180 days comes up, they haven't produced it. You're able to just say the application is dead, you have to start from square one, or?
Or they'll say they don't want to submit any other information, please process with what you have. That hasn't happened to us. I mean, people want to work, like Josh is saying, people want to work with you. They're obviously applying because they want to get to a yes because they have a project. So we haven't had anyone say that to us as of yet. Then it looks like Bill has
Typically, you're not going to submit an application and then not respond when you're asked for more information or say, move forward, I'm not going to submit the information and just sit on it. But sometimes somebody just loses interest and goes MIA and you have to deem the application void.
Go ahead, Bill.
If a situation comes up, and I don't know if it ever has, where there's a code change or something like that, and the party has had something that may be affected by that code change, can they also go ahead and say that they want to make a change in their application?
we'll talk about that. That's going to come up here in a second.
Oh, okay.
I think my next slide might address that, but we'll see it. We still have that
Never
question.
mind.
Related to the 120-day rule is the fixed goalpost rule. It comes from the same statute and says that the decision must be based on the standards and criteria that were applicable at the time the application was first submitted. So if you submit an application and you go through back and forth the process to get it deemed complete, and you get it deemed complete within the 180-day maximum, no matter when it was deemed complete, you've locked in the criteria that were in place when you first submitted the application, not when it was deemed. So if there's a
Sorry, say that
subsequent
one
code
more
change,
time. Say that one more time.
so if you say you submitted an application on January 1st of 2023,
Huh?
as long as it is deemed complete sometime within that 180 days that you have after that, you have locked in code and requirements that were in effect on January 1st, 2023. So even if you don't get deemed complete until April, you still get to apply the code that was in effect on January 1st. So if city council subsequently changes something that would make, this happens quite frequently, actually. I've seen it recently with increased regulations around self-storage units. A lot of communities are restricting those more. Applications that were submitted before the city council made those changes, you're processing them based on the old rules, which can be really confusing for the public and frustrating for everybody involved. We just went through a whole process to develop new rules. Now we're allowing something that we wouldn't allow. We decided not to allow. Well, they submitted their application before then. They locked in that criteria.
If it goes the other way and benefits the applicant, can they then change? Like if they had to build on 5,000 square foot lots and somehow it changed to where it's 4, benefits them, now they can build more houses or units.
It doesn't come up very often, but technically, yes, the statute says unless the applicant elects otherwise.
Josh, can you explain if that also locks them into public works design standards, building codes?
Right. It is any standards, any criteria that were in effect at the time of this application.
So if they required 4-inch, 6-inch pipe and then 4 months later, they deem that isn't suffice, we need 6-inch, bigger throughout the city, they can go with what was originally code at the time of their application.
Right. As far as the criteria that apply to approving that application, they've locked it in. It's a little more complicated when it's probably more than we can get into here when it's things that affect subsequent construction afterwards, right? So if you get, for example, approval of a subdivision, and then you're later coming in for building permits to build that, it's not quite as straightforward. But for the criteria that you apply to making the actual decision was applied for, it's clearly that criteria that was in effect at the time of application.
I will say that a lot of times we'll have in the conditions, it'll say per public works design standards. So we don't specify, so things aren't updated. A lot of those are safety related anyway, so.
Clear and objective requirements. So this is a statute that says that all standards, conditions, and procedures regulating the development of housing must be clear and objective. The rule, therefore, is that if you have standards, conditions, and procedures that are not clear and objective, they cannot be applied to that application. You can allow for what is commonly called an alternative discretionary path, as long as there is a clear and objective path available. So, for example, you're applying to build a multifamily apartment complex, and there are criteria that are clear and objective and say, 40 feet maximum height and 20-foot setbacks, clear and objective. As long as they have that path available, you could have a second path within your code that says you can build taller than that if you show compatibility with the community surroundings, the neighborhood surroundings. That kind of quintessential, not clear and objective standard about compatibility. You can have that still as long as you have a path for them to take that is clear and objective. And recent decisions have been raising the bar, I would say, for what is clear and objective. It is essentially a mathematical formulaic application where any two people applying those criteria would get the same result. So as I noted in my last bullet, it is simple in concept and very challenging to accomplish in reality. writing clear and objective code that accomplishes all the many goals that communities have for how development is going to happen and work in the community uh, is an enormous task. And frankly, very few, if any, uh, cities probably have 100% clear and objective.
Question. So can somebody, a developer, come back into the city and say, when another builder, same area, maybe, for example, they use a standard, but they also use the discretionary path, and so they build higher, to say, and so can another builder say, well, we want to build just as high as they did, but in their case, it's, for whatever reason, it doesn't work. But can they fight that and say, well, you let this builder build this high, why can't you let us build that high? Would that be an issue?
Each land use decision is based on applying the criteria to the specific application, trying to make the correct decision. So it feels a little strange, but this concept of precedent that we see in court systems, right, doesn't apply to city's own internal decisions, its own local decisions. So if you interpreted a code provision one way previously, then it comes back to you and you think you got it wrong the first time, you don't have to do it wrong again. In fact, you have to get it correct that second time. That said, if you are changing the way that you're interpreting code provisions, one, that suggests that maybe they're not clear and objective. And two, there's a potential that, or an argument to be made that there is some other reason why you are interpreting it differently, right? Is it bias that you are biased in favor of or in opposition to a particular applicant? To answer the question in the abstract, it is definitely possible that you previously approved something and then somebody would come back and say, somebody next would come and say, I want that same thing. And you would say, I can't do that. It doesn't meet the current criteria. Also, for the discretionary path part of your question,
Right.
Because it is discretionary and it tends to be more flexibility in how those decisions are made, is more likely and more defensible that you would have different outcomes for different applications, different location, different other aspects of the application that result in those different outcomes.
How do you guys run it, Ray? What do you use normally?
So there are options that are available. We do have the clear and objective, which would be a standard subdivision, say. And then a discretionary path would be like cottage housing development or the planned unit development. So those are less common. Standard subdivision is very, very common. Um, Folks will choose that because they know exactly what to expect. They know what the minimum lot size needs to be. They know what the street width needs to be. And there's not the discretion. So they know they're going to get to a yes as long as they're meeting all the criteria. Whereas it can be a lot less sure what the outcome will be if they're taking a discretionary path. So it really just depends on what the project is and what they're hoping to accomplish.
There are a lot of different constitutional issues that can come up in land use, but I'm just going to talk about the most common that you're likely to encounter or hear applicants or opponents making arguments about. Taking, you've heard that term, is a government appropriation of private property. So under both the Oregon Constitution and the federal Constitution, when the government takes somebody's property, it must provide just compensation. The most common form, the most familiar form of this is condemnation or eminent domain. When the government directly comes in and says, we're taking your property to build a highway, for example. And then there's a whole process you go through with appraisals to determine the value of that property. And then the government pays the property owners for that property. It can also be the result of regulations that limit the use of property, although that doesn't come up very often. Most commonly, what comes up is result of exactions, which are conditions of approval that require transfer of private property in connection with a land use application approval. And typically that's road dedications, uh, construction of improvements, that sort of thing. In order to do that and not have to pay just compensation, not have it be a unlawful taking, you have to meet two requirements: nexus and rough proportionality. Nexus is about the relationship between the exaction and the underlying regulation of the property, and rough proportionality is about the extent of the impact of the proposed development and the exaction. So, for example, um, if somebody is coming in and building a subdivision, and you are requiring them to dedicate right of way for the road system based on the impacts of their subdivision, you're going to look at how big of a subdivision is it, how many units, probably going to have a transportation engineer's report about how much traffic it's going to generate, then comparing that to what you're requiring them to dedicate. So, for example, if someone's coming in with a 200 unit subdivision, you're going to be able to require them to do a lot more in terms of dedicating roads, building roads, than if somebody comes in with a single family detached home and if you requested that they build 1,000 feet of right of way, it's clearly going to violate rough proportionality in that case.
The other option is if you ask and the applicant agrees.
Yes.
We
So
do have that happen as well.
we the interesting thing about exactions is that because the courts use this term rough proportionality, which is not very helpful, and they have said is not a mathematical formula, it is very difficult to establish when proportionality exists and when it doesn't. And so the reality is that it is almost always just kind of a negotiation between the city and the developer, for the city to get as much as the city can and the developer to give up as little as they can, and you come to some sort of an agreement. And unless you're way far apart and can't come to an agreement, probably not going to ever actually talk about disproportionality.
So if you're negotiating like in a subdivision, you're talking roads, is there minimum widths that they have to be? Whether you put how much road and where they are is negotiable, but
Yeah, so in the past, there were concessions on street widths and amenities like sidewalks and other public infrastructure. And, I always keep in the back of my mind, Lori and I, when we're looking at these, is the fire department really has regulations that can't be mitigated for. So they have access requirements and things like that that change the whole, style of development if we don't provide, sufficient width. The other part of it is just sort of operationally, we've had challenges. And so a lot of times especially on street widths, we just, the last couple we've done, we just don't make any concessions whatsoever because it just creates way too many challenges down the line.
But we're not, it's not like there's some kind of horse trading going on for street widths and things like that. It's the code will spell out when we can have deviations, like if there's wetlands nearby or steep slopes or things like that you're trying to avoid. Like the code is very clear. Um, and then the transportation system plan. So it will outline where we expect to see future road connectivity and things like that. So um but to Josh's point, if it is a sort of smaller subdivision and we're saying, no, you got to meet all of our standards and this is what's required, they could push back and say, well, we don't want to meet your standards. You need to show us how that's roughly proportional. And then we would have to go through an exercise to demonstrate based on their trips if we can legally ask for that. And so if they were to push back and challenge us, then that would be where we would have those conversations. We go into it saying, these are our standards. This is what we expect you to provide. If at any point they push back, then this could come into play, but typically it doesn't.
You talked about eminent domain. When typically is that used? I mean, is it usually for specific items like highways or freeways? When else would you see that being used?
That's most common. I've seen it used for citing schools, for example. When I was in Sherwood, they built the largest high school in Oregon by square footage, at least, not by student population, um, and got agreements with some of the property owners that they needed the property from, and not all of them. They went through condemnation with those others. I've seen it used for wastewater treatment plant expansions, that sort of thing, where we really need a very specific property, and you're not able to come to an agreement with the property owner.
The way the Constitution spells it out is for a public purpose. So it can encapsulate a lot of different things like that.
I will add that it gets challenging when we have a project that's, they're kind of land constrained, or their access is constrained. And so for that project to work without compromising our road standards, they may need to buy property from a neighboring property owner. And, we kind of wrestle with how do you deal with that? But, ultimately we're telling them you need to acquire, say, 10 feet from your neighbor so you can build the road to the right width. And they're pushing back saying, you can't make us purchase property from a third party for our project. And that's sort of a challenge. Do you have any comments or have you seen anything like that?
I would agree that it's challenging. There's a lot of different ways that can go. I mean, sometimes I have seen it go to the city exercising condemnation authority to get that property, because it's for a road, or you shift the location of the road or onto the other person's property. But usually it's trying to get people to negotiate with each other, and the city often plays the role of convener or mediator to try to bring those parties together.
And there's an example of that. It's actually the East Airport project. We became mediated land purchase Rosenthal for that road to be full width. Through that, they wanted to actually neck it down. We kind of held our ground and said, no, we need to have a 3-lane section through here. So with the sidewalks. So there was kind of a standoff on that until they were able to negotiate a price. And we actually did mediate.
And sometimes the threat of the at least possibility of condemnation is helpful to get to the table and try to work something.
But you're saying that the applicant could actually request or make the city go through a condemnation process for a private development project?
I'm suggesting more that the city might choose to, through a condemnation process, to
Acquire the
acquire the right of way,
right of way.
or if it's a development that you want to see happen.
If they felt like the project was worthwhile, or I mean, what if it was for like a housing project or something like that?
Yeah,
It doesn't matter.
yeah, as long as it's for I mean, public purpose is pretty broad, as NJ pointed out, and it's for a road and it's for development of the community.
Mhm.
Oftentimes, right of way isn't just needed for that project; it's needed to open up connections to other properties for subsequent development.
So like when I lived in county and wanted to divide our property and put a road to the back, they made me give up 5 feet of the road frontage
Mhm.
right away so that at one time they can widen the road if they want.
That's exactly right. Very common. We do that on most projects. Yeah.
It is fun to drive through Scappoose and you can kind of see the different age of zones.
Mhm.
Some where they didn't even give over the right of way of the roads and they're owned by the neighbors. And then there's some with no sidewalks. And then there's some, you can kind of see the different decades.
Yeah, and there's some areas, especially driving out East Columbia here, you can see where the county lands basically have no frontage has been dedicated, no sidewalks, and yeah, you can kind of tell what's in city limits and what's not. Not always, but sometimes.
That's it for my presentation. I would welcome any other questions on any other land use topics you have or something that you didn't bring up during the slides.
Thank you.
My pleasure.
Very nice
Great.
job.
Just real quick.
Oh, yep. Bill?
There a printed copy of all this presentation we're going to be getting later?
Yeah, we can, I'll take a few stacks back to our office, Bill, if you want to swing by sometime this week.
Okay, just curious. Thanks.
You bet.
And Lori, do you come across any of these for like other counselors that you ever seen that?
Lori actually gave that to me during our kind of pre-meeting, so I do have a
Mhm.
copy of that, but it would be helpful for everyone to probably.
Yeah, I do have extra. Actually, I think I need to make up some more. And if anyone is interested, Jeanette, I may have given you one when you started on the planning commission. Are you interested? Would you like one? Okay, I'll get some more printed.
And have you seen anything, in legislature and state, are we seeing any changes? I mean, I heard a lot of talk about, zoning and, the new administration's talking about that this summer. Do we see any changes at the state level that you guys know of or?
Oh, yes.
Oh, yes.
I think, yeah, it's particularly around housing. Governor Kotek's, as I'm sure you're aware, housing is the number one priority. So in fact, I think every legislative session in the past few years, we've had some sort of major changes relating to housing specifically. And I definitely anticipate for this session. The big one that you may have heard of, you may have heard people talk about HB 2001 a few years ago. Well, there's a new HB 2001, just a coincidence of numbering, I guess, that would dramatically change the way that housing needs analyses are done. Current proposal, at least the last time I looked at it, essentially right now, local governments do their own housing needs analyses and have a lot of local control over that. There would instead be a statewide housing needs analysis and an allocation to each community of how much housing they need to produce, and then a monitoring of whether these meet that goal.
Produce or have land available for others to produce.
Produce. So not building yourself, not building it yourself,
Land
Right.
supply.
but not just land supply, that it's actually being
You have to
developed.
market it and develop it. And
You're not marketing and developing it, but the concern, I guess, and this is part of the shift, is that it's previously just been about land supply. You have enough land for it, but you have onerous regulations around actually developing that land that make it difficult or pencil out to develop that land. Then I guess in the
see.
state's mind, that is not enough. That you just have the land available. You have to have a whole system of regulations
So no
makes it feasible.
barriers. Okay.
to remove those barriers, right?
And it's oftentimes not really a function of a developer rolling into town and putting up a building. I mean, that's a known, right? A house is a known cost. It's all the site work and the utilities and the street improvements. Those are the unknowns. No, those are the challenges. Those are the barriers that I see.
Would those onerous barriers include things like design standards and SDCs?
Essentially.
That could
There's
be
there's a
problem.
lot of conversation around SDCs. I don't think that there's a proposal that people have rallied around yet, but it's obviously a complicated issue because SDCs clearly the development community says SDCs prevent construction of housing or lead to increased costs of housing. The flip side of that is that without SDCs, how do you pay for the infrastructure that
Correct.
is needed
To
for
serve
that
them.
Well,
Yeah.
So there's been some concepts floated about waiving SDC requirements for affordable housing developments, or I think most cities would prefer the one where the state pays the SDCs for affordable housing.
Yes, I
developments,
would. Thank you.
Great.
Instead of just waiving those because that infrastructure is still needed.
Right. Well, that's the thing. It doesn't, just because it's low income housing, it doesn't eliminate the need for us to provide the infrastructure to serve it. So that's pretty worrisome. And I think in general, what I'm seeing from the legislature that I found concerning is just that it's very heavy-handed. It does seem like the state's taking away a lot of our home rule ability to actually set policy that makes sense for individual cities. And I'm seeing that a lot, and it seems like that's something that the LSC's been really concerned with too.
Yes,
Mhm.
absolutely. The other thing too, not just this, looking at this legislative session, a lot of the things that have been done in the last couple of legislative sessions are just now starting to percolate out to actually be seen in
Mhm.
communities. So, for example, I saw just a few months ago my first proposal under Senate Bill 8 from 2021, which essentially allows for siting of affordable housing if certain limited criteria are met anywhere, even if it's a commercially zoned lot or an industrially zoned lot, where you typically wouldn't allow housing. For an affordable housing application, you have to allow it.
Bill?
Yeah, I think affordable housing obviously is an important part of our strategy, but I definitely think that there'll be a pushback, especially in the rural areas, uh, for what you're talking about. So it'll be interesting to see how long it'll take to get that to happen and where it goes. But it definitely would affect how the city definitely plans. There's no doubt about that.
Mhm.
Like I said before, the more rural parts of town, they can't develop because there's no infrastructure. That's really the limiting factor. And with regard to SDCs, usually in infill, like in a developed city urban environment, those utilities are in place already, and you've essentially already sort of captured the expense for those on in a city. And so there are cities that do waive or reduce SDCs for infill projects. And there are studies that have been done that show that, if you can incentivize development in a infill type situation, you can get tax payback on those reduced, say, fees or SDCs within, a 10-year-ish window, depending on the extent of the.
We don't have those, that properties.
Well, we don't have that policy.
We have those properties.
We have those properties, but it's actually in our code that we don't waive SDCs.
So the state requires us to have the supply and then they'll go out and try to entice and market builders and developers to make it advantageous for them to start building in our areas that we have available.
I don't think the proposals are really about the marketing at this point. It's more about land availability and removing barriers in development codes.
But mostly so centered around affordable housing.
Yes,
The provision probably of all housing.
all housing, yes. Right. The driving concern is affordable housing, but yes, housing in general.
Yeah.
That's similar to the clear and objective standards part, right, is to try to make it easier for those developments to happen, and then the theory is that they will happen.
Problem I see with affordable housing, and probably everybody knows this, but it rarely do the affordable housing units get purchased by people who are low income. Usually purchased by people needing a rental or it's unless there's a requirement for it to be sold to a person of with low income. And I don't think there's anything like that to any broad degree right now. A lot of those places just get purchased by people that want rentals.
Well, and yeah, so that's kind of the reason we talk about the difference between capital A affordable housing, which does have those kinds of income requirements by county medium income, versus lowercase affordable housing, which is just lowering the overall cost of general market housing.
So how many units do we have with the previous one you mentioned?
There's the it was developed by CASA, but it's the development kind of behind the Napa. What street is
Oh, the orange building.
Yeah.
Sycamore? Yeah, and so that was constructed for farm worker housing.
Yeah.
So I know that that one in particular.
Those are rental units.
Those are rental units. And then Habitat for Humanity is going to be building, they're going to subdivide their 2 lots into 10 lots. And so they would have attached single-family housing on those.
That's why I'm so passionate about Habitat, because
Mhm,
as far as I know, they're the only ones that really
mhm.
do that, to make those homes available to people who are lower income. It's, I mean, you still get a unit that's gonna rent for less maybe than what it would otherwise, but nevertheless, it's not solving the problem by
Right.
putting up low income housing. Did see Senator Wyden had a program, I don't know where it is, but he's talked about it on TV a couple of times about giving incentives for people to build homes so exclusively to people with low income. I'm not sure how that works, but it's,
For home ownership.
yeah.
Oh, great.
Low income, I think it's just affordable housing. I
Right.
think that's.
That's right. Yeah.
And I guess just one follow-up question. So with some of the changes potentially being considered in the state legislature, say some of those were to pass, those would all get factored into the 50-year plan work that we're doing, Lori? Are we?
Well, it's interesting because I don't know where we'll be in that process. To be continued. Yeah,
Sometimes there's different rules about when those things are implemented and,
right.
you know, how that
Right.
works. If you have a plan that's already done, you know,
Right.
does it immediately need to be updated? So usually a lot of stipulations that come in those that we'd have to look closely at.
Mhm. But the thought about the statewide or the state creating the housing capacity or housing needs analysis would be an interesting one.
Yes.
One, reading the tea leaves,
Mhm.
which isn't what I do, but the people who do say that one is virtually guaranteed to pass.
Wow.
Really?
Two ones I have. So like the 19 goals, when you guys get an application, do you go through the 19 goals and make sure they're all met or applicable?
Only if it's legislative and they're changing the development code text, comp plan map or text, then we have to look at it against the statewide planning goals. If it's just a local application for quasi judicial decision, we don't look at that.
Just to expand on that a little bit, when you adopt your development code or your comprehensive plan,
Mhm.
it's sent to DLCD to review, and they do what's called acknowledging it. Once they have acknowledged it, it is deemed to be implementing those
Yep.
goals, and that's why you then don't have to apply the goals directly because your code, your comp plan are effectively the goals.
Mhm.
And how does this affect at all? I mean, or how is a UGB expansion handled? Is it or any at all like handled in these quasi judicial
It's legislative.
legislative?
So all the information we provided on legislative decisions would apply to a UGB amendment decision. Obviously, it's affecting the entire city. And so that would, yeah.
Is that something after the 50-year process and we've gone through it all, that's something you as staff think that is something you want to recommend to planning commission and council?
So that is definitely something we're actually moving into looking at right now. And so our consultant team is putting together the maps where they have to look at, for a UGB expansion, they look out a half a mile beyond the current UGB limit. For the urban reserves that we're looking at, they look out a mile from the current limit, and then they create essentially sub areas that they'll evaluate to see if it would meet the criteria to consider for bringing it into the UGB or establishing urban reserves. So, what would come out of the 50-year plan at the time that we're adopting all the changes would potentially be a UGB expansion, establishment of urban reserves, zone changes so that we're looking at land use efficiency measures so that maybe we're not ready to expand right now. Maybe we just rezone certain lands we already have in the UGB, things like that. But that will definitely be something that comes out of this plan is that analysis and a recommendation. So yeah, and that because it's legislative, it would go to planning commission first. They would make a recommendation to council. And council would be the decision-making body. However, obviously, this is a 3-year plan we're working through. There's going to be lots of touch points with the community and with the council and the planning commission, just so that you're being kept up to speed kind of as we go through the process. You kind of know, which way we're leaning, and the consultant's going to want to hear your concerns, about what we're proposing. And so we'll work through that so that hopefully by the time it's hitting your desk and you guys are here to make a decision, you will be fully aware of where this has gone through the process and hopefully up to speed on everything.
And then if there's approval, it's done, and then there could be an appeal, just like.
Yeah, so once now any decision that council makes, then there's a 21-day appeal period. That's how much time people would have to file a notice of intent to appeal with LUBA. That's why our ordinances don't go into effect for 30 days. That allows that 21-day appeal period to LUBA, in which case they would take it up and we would see what would happen from
And if
there.
nobody does it, the state doesn't okay UGB expansions.
Yes, they most certainly
would
do.
look at it.
Yeah, they would absolutely. Yeah. So before I can even bring it to the planning commission, there's a certain number of days prior to the first hearing that I'm required to notice DLCD of any change to our comp plan or development code. And they have that time to review it to let us know if they see any issues with what we're putting forward.
How does the urban reserve differ from the UGB?
The urban reserve is land supply that would be held in an urban reserve, but still in the county until such time that we've used up enough land in our UGB that we're looking for an expansion. That urban reserve land then is there. It's just a slightly easier approach to do an expansion of the UGB if it's already identified as urban reserves. For us, we're looking out 50 years for this plan, so it would be land that we would need from the 20 to 50-year horizon. The 0 to 20 years is a typical planning horizon for UGB. You need to keep a 20-year supply, essentially, of land for housing and for employment. Yeah, and so there would be partnership with Columbia County so that Columbia County might have different, basically, guidelines and rules for how that land can develop while it's still in that urban reserve. In other words, it wouldn't allow that land to be split up into smaller parcels, or potentially you could do some partitions, but not anything at an urban level, because the thought is that you're holding together those larger pieces of land that that would come in and be able to be developed, whereas you don't want like a house in the middle of a 5-acre parcel type thing.
Do we have any urban right now
We,
reserves?
yeah, no, the city currently does not have urban reserve lands designated.
Homeowners typically in favor of doing that or not?
Well, maybe I'll defer to Josh on that. Maybe he has some information on that.
I haven't seen a lot of designation of new urban reserves happen, or a lot of opposition or support for that. It's just not.
I think it does potentially increase land value, knowing that it's going to come in someday. So depending on what that family's long-term goals are, they might think very favorably of that. But I
Such a
couldn't
long
say for
time
sure.
horizon.
Yeah.
Mentioned, it means that you're at least 20 years out,
Yeah.
actually up to 50.
Yeah.
I mean, you're constraining their development ability though, if they're purely just in the county. And so if they've got to stay with these bigger parcels and they can't subdivide it and sell those properties off, I would tend to think that they're going to be less in favor of agreeing to that
Depends on-
than a UGB expansion where
Yeah.
they can annex in and then have all of the city, all of the city land use requirements would allow them to organize it to, really small developable lots.
Are we limited though on the lands that you can look at? You said half mile out to a mile out, but are there certain lands like farms or nursery lands that you can't touch.
That's correct. There's a hierarchy essentially of land. And so they'll have to go, our consultants will go through to figure out which land they can consider and not consider. So high value farmland off the table. Unless there was literally nothing else available for a city to use, and they had that demonstrated land need. But that's not the case here. We do have lands that aren't high value farmland that we would look at first.
Bill, you got a question?
It's really, I think it's probably, the answers is going to be simple enough, but if you did have an approved reserve area, as you mentioned, then would it be just sort of like an annex situation where the property owner there would have to make a request to be for an inclusion in the city boundaries, just like, you know, an annex? How would that work? Would we
Yeah.
wait for them to make the first overture, or would
Well, the
reach out?
land the land in the urban reserve wouldn't be in the UGB until we did a UGB expansion to bring that land in the urban reserve into the urban growth boundary. At that point, then the homeowner could request to annex into city limits after they're contiguous to city limits. So it's still sort of quite the process to go through. But if you've already sort of designated the land as an urban reserve area, it's just slightly easier to do that UGB expansion because it's already been agreed upon. It's already known that that's an area you plan to grow into. So, yeah, the landowner could initiate the UGB expansion, but typically that's something the city's going to do once they can show the need for that land.
Okay.
In our last UGB expansion, I mean, it took some time.
Mhm.
Was it contentious? I mean,
Very. Was tied up for how many years in court? 5?
I started on planning commission when that first came to the city, and it lasted the whole time I was on planning commission,
10 years.
about 8.
8 years.
It was contentious. The room was packed.
Scott,
I just wanted to say there is no requirement that a UGB expansion will be, painful. There's just every likelihood.
Yeah.
And there was a lot of misconception around it too, in terms of what thought what was happening to them. And so some people were adamant that they didn't want to be in it because they thought that the city was going to make them pay for roads and sewers and water lines, and that they were going to be taxed much differently. And no, that's just not the case.
There were some people that wanted to be in it that weren't in it.
That's correct.
shit,
Yeah.
anything?
Might add that there was also a lot of thought on if you tried to expand the areas that were available were not always developable for our purposes. You know, there were situations there where people were thinking, boy, if I got into this, I could do certain things that maybe they couldn't do.
As you do the reserve, you'll deem this as commercial lands, potentially, it's just lands.
Actually, no. When it's in the urban reserves, there's no designation on it. You don't even have to say, it's going to be parkland or it's going to be employment or it's going to be housing. It's just stock that you can use. And at the time that you're going to bring it into the UGB, then you designate it on the comprehensive plan map. If it's commercial, industrial, housing, etc.
To study to determine what to bring in as a reserve. I mean, they have an idea, so they're not bringing in all one type
It's
of land.
It's just straight acreage. But I would imagine that, and we're just getting to that point in the process. So I have not seen this process before, so I'm learning as well. I don't know that urban reserves are done a whole lot across the state.
That's why I was saying I don't see it very often.
Okay.
So when we do decide, we're picking an area and going that direction versus saying the whole area.
So they're looking, like I said, they're doing the half-mile look for UGB and then the mile for urban reserves. And
All
so
the way around this.
all the way around. So I would imagine you might choose a few different sub areas that maybe it makes more sense for housing in this area and it might make more sense for, industrial up here or something to that effect. So
So then, are there conditions that would exclude land for the urban reserve, like slope or
Yes.
wetlands?
Yeah. all that, yeah,
floodplain?
that's right.
So-
Yeah, you're constrained lands. We know it won't go in
To the west.
particular ways. Yeah,
Land, slope.
Yep.
So.
That's right.
yeah.
north and south,
And-
not east and
land
west.
that can be served too.
Yeah, and we are also looking at that. Like, it would make more sense to bring in land near Callahan Road than it would near Wickstrom or, something really, really far to the north because, we're not going to have utilities to serve that area for a while.
And they can bring in areas that have already been developed, but typically we don't have that. I mean, Highway 30, we have some businesses in county, but you typically bring those in. UGB or undeveloped lands.
Well, we want it to be land that will accommodate the growth that we need. So you're going to want to bring in the land that is vacant or partially vacant. But if there's, say, development, here, and then what you're looking at is bringing in something a little beyond it, then it might be that you bring that in to get to the property that you're looking for.
Yeah, you're not going to leapfrog, and that's one of the problems with
Correct.
land development in the county, because normally they're developing on your periphery. So you have to, when you do, my understanding is anyway, the UGB expansion, you have to bring them in first, and then you go beyond them and bring in the additional that you need. So for instance, we have a whole bunch of 5-acre lots that have been built up JP West now. And so we'd have to bring them in if we wanted to grab that vacant land that's up above that on the hill.
It does have to be contiguous, but sometimes you get creative with that means what's called a cherry stem. Right?
Hmm.
Kind of a
Or
narrow
south-
part and then a wider part, right?
Or south of Highway 30 do we go?
All the way to Johnson Landing, but just
I thought
down
it
the,
was
just down the land between the highway and
Old Portland Road.
that little sliver.
Less than Goddard's property.
Yeah, not on that side. Yeah.
And none of that can be served with sewer unless you spend quite a bit of money on a sewer station.
Yeah.
Like if you went beyond Bonneville, you'd have to bring in all of Bonneville first.
Hmm.
Service them and then you could expand.
We're not showing a need for that much acreage, so yeah.
Bill?
Yeah, just one little thing I remember from years ago. And that is that Portland State did a lot of population studies that were projected and where our growth was going to be. And I know there was some shocking figures for a lot of people, but I can't remember, but there were figures like 20,000 population, this little community. I don't know if that'll ever happen, but definitely they'll be looking for other resources if they ever want to get that kind of population out of here.
Yeah.
One thing I do ask is on the Portland State Studies, the school district is looking at a 500-person mid-school because they're expecting contraction. They're short, they're getting smaller,
Mhm.
but yet our population says it's growing. I mean, are there correlation there? I mean, it's the same studies. It's just, are we not gaining school-age kids? We're gaining a lot of people that don't have kids.
I think there is a shift in the demographic to where families are getting smaller. And so, our growth, our projected population forecast increase was like 1.2%. It's not a lot. And I've heard the same thing from the school district. They're just, enrollment is down.
We have smaller classes than I did 30 years ago.
Yeah.
Absolutely.
now.
We actually have less kids.
Yeah.
So
We'll have a 200-person class, but a 130-person class.
the problem comes in, like you're saying, different sizes of classes, but you've got, I think, 3 private schools and 2 charter schools that take
Mhm.
away from our school population now, mostly up to 8th grade. After
Mm.
8th grade, they usually tend to, so the high school is not as impacted, but it's a real problem because when I was principal at Peterson School for 10 years, You had 6 classes of 4th, 5th, and 6th graders, all 3 grade levels, 6 classes. Now they have 4.
And if we start to build to change, if we do get more apartment complexes where we do start to grow, that will start growing the kids as well, depending upon the type of housing we do build.
Those charter schools have cut into our school population. As have the private schools.
Anything else?
Well, I don't want to keep us here whether we have to, but it's something,
28 seconds.
28 seconds. So I mean, 7,000, we're pretty close to 10,000. I know that after 10,000, certain rules and things changed, we're keeping that in mind, right?
Yeah, we're actually a little over 8,000 at this point, and some of the changes we actually made before they apply to us. So yes, we're keeping an eye on that. We're making changes just ahead of time if they make sense for us before we're even subject to those requirements. But yeah, we're keeping an eye on that.
So like with Little League, you have to follow their guidelines, but you can improve upon it.
Right.
You just can't do less.
That's right.
Yeah, the state's always setting the minimum. You can go above and beyond that, but you can't drop below the minimum.
Because if our growth is 1.5% or so, and it could be a little higher, we're looking at 10,000 within the next 10 years.
Hmm.
Actually, 8 years. We might as well be looking at that. You start making your,
We have been.
okay. Thank you very much. Appreciate it, Josh.
Thank you, Josh. Great job.
Adjourned.
Look at
Thank
you
you,
finish